What is Section 702 of FISA? Have you ever wondered how the government monitors communications in the digital age? One key piece of legislation that plays a role in this is Section 702 of the Foreign Intelligence Surveillance Act. This law was passed in 2000 and allows U.S. intelligence agencies to collect electronic communications from non-U.S. persons believed to be outside the United States. This includes emails, texts, and online chats. The government can requiring American technology companies and internet service providers to help with this surveillance. The main goal is to gather foreign intelligence, especially regarding threats like terrorism and espionage. But how does this all work? The process starts with annual certifications from the Attorney General and the Director of National Intelligence. These certifications outline the types of foreign intelligence the government wants to collect. They are submitted to a secret court known as the Foreign Intelligence Surveillance Court for approval. Once approved, intelligence agencies can target specific non-U.S. persons abroad without needing a traditional warrant for each individual. It is important to note that Section 702 is not meant to target U.S. citizens or anyone inside the United States. There are rules, called minimization procedures, designed to limit how much information about Americans is collected. However, these procedures do not always prevent the collection of Americans' data. Section 702 is often described as a targeted program rather than a bulk collection system. Each targeting decision is supposed to be documented. The law also prohibits reverse targeting, which means agencies cannot intentionally target a foreigner abroad to spy on someone in the U.S. However, the line between incidental and intentional collection can be blurry. This law was created to fill a gap in surveillance capabilities as global communications increasingly flowed through U.S.-based companies. Before Section 702, the government had to seek individual court orders to monitor foreigners, which was seen as slow and resource-intensive. From a national security perspective, Section 702 is viewed as a tool to quickly adapt to evolving threats. Supporters argue it is necessary for protecting the country from external dangers. However, from a libertarian viewpoint, Section 702 raises serious concerns about privacy and individual rights. Libertarians generally oppose warrantless surveillance and mass data collection, viewing them as violations of the Fourth Amendment's protection against unreasonable searches. The fact that Americans' communications can be incidentally collected is seen as a threat to civil liberties. There is skepticism about the effectiveness of oversight, given the secrecy of the Foreign Intelligence Surveillance Court and the broad discretion given to intelligence agencies. Libertarians argue that any surveillance affecting Americans should requiring individualized warrants based on probable cause. In practical terms, if you are a non-U.S. person outside the country communicating with someone in the U.S., your communications could be monitored without a traditional warrant. If you are a U.S. person, your communications with those targets could also be swept up. While there are rules to limit how this data is used, the potential for abuse remains a concern for those who prioritize privacy and limited government power. Libertarians believe that Section 702 undermines the principle that the government should not intrude into private communications without clear suspicion. The lack of traditional warrants and the secretive nature of the process conflict with the ideal of transparent government. The incidental collection of Americans' data is viewed as an unacceptable erosion of privacy. For libertarians, the balance should be to requiring warrants for any surveillance that could affect Americans, ensuring that liberty is not sacrificed for security.